These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We left off on step 3. So, step 1, remember, was our tender to the IRS for set off of the account. Step 2, we're basically giving notice and demanding certain levels of performance from the bank based on the tender for set off, right? So step 3, at this point, this process presumes that they haven't performed. Now, if you got your deed of reconveyance, they actually performed on step 2, no need for step 3, okay? However, if they haven't, as creditors, we're not only going to give them a little bit of due process by going into step 2 here, because step 2 is, oh, by the way, you didn't perform. So we're going to give you an opportunity. I'm going to give you 10 more days before this specific power of attorney goes into effect and I start executing this stuff on your behalf. Okay? So, first 2 documents, you'll notice 3.1 and 3.2 are a certificate of non-performance and a certificate of non-response, both of which were mentioned in step 2. So first we'll look at our certificate of non-performance. Okay. So, certificate of non-performance, we have at the top, presentment, be it known that the person signing below, a duly empowered notary public, at the request of John Henry Doe, in care of this address, which is usually the notary's address, did duly present on May 28, 2010, the attached notice of tender for set-off and request regarding a statement of account. Remember, both of those documents had performance duties within them. Request regarding a statement of account had the duty of correcting or approving the statement of account. Did it not? The notice of tender for set-off had duties of issuing or executing a notice of rescission, issuing or executing a statement of account, executing or issuing reconveyance of deed, right? So there are levels of performance on both of these. The notice of tender for set-off and request regarding a statement of account dated May 28, 2010. 2, name of the CFO, care of the bank, signed by John Henry Doe, demanding performance of the following duties: to give notice of and execute or cause to be executed a notice of rescission and deed of full reconveyance. the time limit having elapsed for timely performance thereto. Default, whereupon the notary public signing below for the reason dishonor by non-response / non-performance does publicly and solemnly certify the dishonor is against all parties it may concern by reason of non-response, non-performance thereof, and stipulations therein. Notice, the undersigned notary public certifies that on June 30th, notices of fault were sent to the parties noted below by depositing in a depository of the United States Postal Service within the state indicated herein a sealed envelope containing said notices directed to the respective persons or entities at the last known corresponding addresses noted below. Has the name and address of the recipients of our notice of fault. Notice of fault is 3.3. This is document 3.1. The certificate of non-response is document 3.2. And our notice of fault, which we're saying is being mailed out the same day that we're executing this certificate. Am I mailing this certificate? No. I'm just putting in the certificate that a notice of their non-response, non-performance in the form of a notice of fault is being issued and mailed.
Is it your intent to call it a default as you do in the second to the last paragraph as opposed to fault?
Yep. Testimony. In testimony of the above, I have signed my name and attached my official seal. And then you have the notary signature, commission expiration, and the date of execution of this document. So now we're going to look at the certificate of non-response. Certificate of non-response. Presentment. Be it known that the person signing below, duly empowered notary public at the request of John Henry Doe in care of the notary's address, did duly present on, should be the same date as the last one. But like I said, these documents are all thrown together. So May 28th, the attached notice of tender for set-off and request regarding a statement of account dated May 28th. 2, CFO of the bank, care of the bank's address, signed by John Henry Doe requesting correction or approval of the statement of account. Remember, in our notice of tender for set-off, we said that a certification of their non-response would be deemed acceptance or approval of the request regarding a statement of account. So default, whereupon the notary public signing below. Wait. Let me finish that statement up above. Requesting correction or approval of statement of account, the time limit having elapsed for a timely response thereto. Default, whereupon the notary public signing below, for the reason of dishonor by non-response, does publicly and solemnly certify the dishonor is against all parties it may concern by reason of non-response thereof and stipulations therein. Testimony. In testimony of the above, I have signed my name and attached my official seal. Boom. Document 3.3, our notice of fault. Same statement at the top. This is private communication between the parties. Notice to agents, notice to principal, notice to principals, notice to agent. I call this a notice of fault and dishonor, opportunity to cure. Dated June 30th, has the same principal and respondent information, and it also has reference to the account. Statement of facts. So this is actually, this notice of fault, opportunity to cure, is in the form of an affidavit. On May 28th, John Henry Doe, hereinafter principal, made presentment of a notice of tender for set-off and a request regarding a statement of account, hereinafter presentment, via so-and-so, notary public, hereinafter notary. 2, chief financial officer guy, hereinafter respondent. On June 4th, 2010, United States Postal Service, hereinafter carrier, successfully delivered the presentment to the respondent. As of June 25th, 2010, respondent has not sufficiently responded to the presentment. On June 25th, 2010, principal made presentment of a notice of fault in dishonor. Okay, this actual, again, this is where critical thinking comes in. When I authored this process, it was correcting a notice of fault that had already been sent in. So you would actually eliminate this line, number 3, because it says right here on June 25th, 2010, principal made presentment of notice of fault and dishonor. Wait a minute. Aren't we making presentment of a notice of fault right now? Opportunity to cure. Hereinafter, defective fault notice. Said presentment contained defects and is hereby rescinded. You see how contracts are fluid and dynamic. Oh my God, I made a mistake in my process. Okay, correct it. I just corrected it. Respondent's failure to sufficiently respond or timely honor the presentment, we're still talking about step 2, by the terms of the presentment, constitutes respondent's acceptance and approval of the request regarding a statement of account contained therein. Respondent's failure to perform by the terms of the presentment constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. Number 6, respondents are at fault. Number 7, as an operation of law, the respondent by dishonor of the presentment has created a fault. Opportunity to cure. In the event that the respondent's failure to respond to the presentment was an oversight, mistake, or otherwise unintentional, principal grants respondent 10 days, exclusive of the day of receipt, to cure the fault and effect the remedy. The respondents have 10 calendar days to cure their dishonor by the following. 1. Correct the statement of account contained within the request regarding a statement of account by the terms stipulated therein. Remember the terms? A verified statement of account they must sign. Number 2, execute or cause to be executed a notice of rescission. Now notice, 1 or 2. Why or? Well, because if they actually do correct it and sign under penalty of perjury that it is something other than 0, well, then I can't really demand they execute those other documents, right? So they're either going to execute a new statement of account, or they're going to agree that it's 0 and do these other duties, perform these other duties, duties. So they will execute or cause to be executed a notice of rescission and a deed of full reconveyance in accord with the presentment and pursuant to the deed of trust recorded on or about November 3rd, 2005 in the Office of Los Angeles County Recorder as instrument number blah, blah, blah. I'm basically telling them, perform by the trust we originally created. Remember, the trust said, when I pay you off, you're going to reconvey the deed. You've been paid. Stop breaching the contract. Right? Who's in breach here? They are. So we're saying not only by this new agreement that's been established by the last couple of presentments, but pursuant to the original deed of trust or mortgage agreement. You said you were going to perform this way. Failure to cure will constitute, as an operation of law, the final admission of the facts set forth in the presentment by the respondents through tacit assent to the presentment, and the whole matter shall be deemed res judicata and stare decisis. What does that mean? It is already decided. They will be admitting all the facts contained in our initial presentment and all the facts contained in this presentment. Nothing else can be decided. There is no arguing these facts if they fail to respond.
Res judicata is against the world.
It's against the world?
Yeah.
What do you mean?
When it's deemed res judicata, it's deemed against the entire world. It's a cool statement, in other words. You did a nice thing there.
Response by respondent must be served on principle exactly as provided. John Henry Doe, care of the notary, and notary's address. Now notice here, again, double witness to the jurisdiction I am executing this document in. Remember, top of the document said this is private, right? Now I'm going to put on here a commercial affidavit, oath, and verification. I, John Henry Doe, secured party creditor, under my unlimited liability and commercial oath, proceeding in good faith, being of sound mind, having first-hand knowledge, affirm, state, and declare that the facts contained herein are true, correct, complete, and not misleading, under penalty of international commercial law, so help me God. This 30th day of the 6th month in the year of our Lord 2010, witness my hand and seal. Then here comes the jurat.
What's the difference between the notary and the jurat?
The notary is a person. A jurat is a statement made by the notary. A jurat, you mean a jurat and an acknowledgement?
Yeah.
An acknowledgement is merely I'm acknowledging who signed the document. A jurat is the notary is actually administering that oath you just took above. See, the notary also has the power to administer an oath. Okay? An oath under a witness takes on a new level of significance and power, in that an oath taken by yourself doesn't have that much weight to it. But an oath taken in witness of someone else is, what's the word rather than irrefutable? Dispositive. Okay? So they're acting as a witness to as the administer of the oath.
Yeah, dispositive is that which cannot be challenged.
Okay? So we're right here, you notice in the wording, subscribed and sworn to or affirmed before me on this date by the principal, proved to me on the basis of satisfactory evidence to be the person who appeared before me. So they're doing, not only are they testifying that you subscribed, sworn, or affirmed the statement and made an oath, they're also subscribing that you're the person. So whereas an acknowledgement is merely saying this is who showed up and executed the document. A jurat is saying this is who showed up and I administered an oath to them. That's the significant difference between a jurat and an acknowledgement. Okay. Enclosures. Attachment A. Record of presentment consisting of A. Notice of tender for set-off. B. Request regarding the statement of account. C. Notice to set off accounts. D. Mortgage statement of account, money order. E. IRS Form 1040. F. Certificate of service. G. Certificate of non-response. H. Certificate of service for step 2. So remember, this certificate of service is a certificate of service for step 1. This certificate of service is a certificate of service for step 2. And I'm going to include the USPS Form 3806, receipt for registered mail, and the USPS Form 3811. I've now brought all my witnesses in. Right? Not only the notary, but the post office. I've now included all the records. And the certificate of service for this presentment. So this is a 3-page notice of fault. This is the cover page, attachment A. It's like the cover page serves as like a table of contents of the record that follows it. So it's much like what was listed on the enclosures part of the first page. But it says right here, attachment A, giving it the title, designation, a inference or a distinction of this attachment being record of presentment, and then underneath that, subheading 4, notice of fault and dishonor, opportunity to cure, number, and that's the registered mail number of the notice of fault, opportunity to cure. This section, attachment A, includes, and then it lists 1 through 11, all the items and the number of pages of each item. This section includes a total of 14 pages, not inclusive of this page, the title page. So in all, it's 15 pages. So I've got a 3-page notice of fault and 15 pages in addition. So how many total pages? 18. Plus, there's going to be certificate of service. So if the certificate of service is 1 page, how many total pages? 19 pages. 19 pages. Okay? Notice how I've even broken down in the certificate of service, attachment A, record of presentment, and then all the elements of the record of presentment are sub-categorized under number 2, attachment A. So I've got number 1, the notice of fault. Number 2 is the record. And in the record are all these elements, A through K. And then number 3 is this certificate of service. Okay? That is our step 3. What is the purpose of step 3? Opportunity to cure, a second witness to all the facts, presentment of the record of everything that's happened up until that point. Have we not? So this is our due process. So, what do you think step 4 might be? Whoa, 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 there ain't even a court case yet, my friend. What typically comes in due process? What comes after a notice of fault?
Notice of default and dishonor.
What else will be included in there?
The entire record.
What else? What else happens? Not what's going to be included with the default, but what else is going to happen in step 4?
Consent to judgment.
That's part of the notice of default. What other documents get executed? Are we going to certify their non-response to the notice of fault?
Yep.
Okay. So step 4, we're going to have a certificate of non-response. Then we're going to have our notice of default. The certificate of non-response is certifying their non-response to the opportunity to cure. Step 3.
Excuse me, Brandon.
I keep forgetting that I already had these all open. Yeah.
On your that flyer there behind you, are we still in step 2, perfect interest and title, or have we moved into effect remedy?
We're still in settling the
account.
We're
still in settling that? Okay. All right, thank you.
Step 5, we get into perfecting interest and title.
Okay, and then step 6 is the following one?
If you've already got possession, there's nothing to do for step 3.
Okay, great. Thank you.
So here we have I actually entitled this Certificate of Non-Response / Non-Performance because the notice of fault is still demanding a level of performance, is it not? Remember, their opportunity to cure was some form of performance, was it not? Okay, so now I'm certifying their non-response, therefore agreement to the facts. Because remember, notice of fault was an affidavit, right? If they don't respond to an affidavit, are they not in agreement with all the facts? Okay, so I'm certifying both their agreement to all the facts contained within the notice of fault, and I'm certifying their lack of performance or failure to perform the 2 points that we gave them within that opportunity to cure. We gave them 2 possible ways of performing. So, again, typical language all the way down to what the presentment was made of a notice of fault and dishonor opportunity to cure. What was it requesting? Curing fault by stipulated performance or correcting statement of account, right? Because those were the 2 forms of performance, remember? We said, number 1, correct the statement of account, or number 2, execute all the stuff we told you to execute in step 2, or in their eyes, step 1, which was the notice of tender for set-off. We were basically saying, execute notice of rescission, execute reconveyance of deed, execute, whatever we told them to execute. That was the other form of honor. And then we're saying down here under notice, the undersigned notary public certifies that on the date of the execution of this certificate, that a notice of default were sent to the parties noted below by depositing United States, blah, 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 blah. Okay, so you notice that each of these certificates, the language changes, guys, not just what's in the field boxes there. So this particular certificate is really only relevant because of this language here after a notice of fault, because it's making reference that a notice of default is being sent out. What's that? Oh, shoot. Yeah, there's an F missing. Again, you better read this stuff. What the hell? Oh, Garrett's on it. I'm like, what's going on here? Hit Control S. Okay. So that is what, 4.1? So we need 4.2, notice of default. Notice of default, much like notice of fault, is in the form of an affidavit. I call this notice of default in dishonor consent to judgment. What kind of a judgment? Administrative judgment. They are consenting to judgment at this point. And, of course, it's private. Every step of the way, private. We have our principal and respondents at the top. Here's our statement of facts. On April 23rd, 2010, principal, or actually, this particular process was being executed by one party on behalf of another party. And you guys can rewrite your processes such that, oh, I want to go help so-and-so do their help with their house, but they don't know what the hell they're doing. So I get them to execute a commercial security agreement making me the paramount security interest over their stuff. Right? So now I can go execute anything and everything I need to because we have a private agreement where I have control over their set-off account, their private trust account, their property, their straw man's property, their birth certificate, everything that is a part of their public trust, they're going to grant and convey to me the paramount security interest. And now I can be the principal, but in this case, someone else was the trustor on the deed of trust. Now, if it was your straw man that was the trustor on the deed of trust, then it would be the name of your straw man. Okay? So on June 23rd, 2010, so-and-so, hereinafter trustor, made presentment of a notice to set off accounts, mortgage statement of account, and money order. See, in this particular process, the step one was done under the party you were helping, right? Because you're using their set-off. Because it's their obligation. Now, I've actually successfully set off other people's debt with my private asset account. I had a friend who had a State Board of Equalization debt for $90,000. I used my private exemption and set off the debt. Now, it was a corporation's debt. I don't know necessarily that it would work if it were a U.S. citizen's debt, because there's a different designation. A U.S. citizen has the authority of its creation isn't the state of California, but this particular, when I was doing it for this corporation, it's a corporation. Anyone can set off its debt. You know what I mean? So I don't know if that's why it worked, and it may not work, but because we're unsure, we just said, okay, we'll have her do the set-off. And then, since I've got the paramount security interest in all her property, I'm going to execute step 2 through 5 because she's not competent. Okay? So, hereinafter trustor made presentment of step 1, which was our tender for set-off. Hereinafter tender, a record of which is attached hereto and incorporated herein in its entirety as attachment A. To IRS Technical Support Division, hereinafter tender agent for the set-off settlement enclosure of account number, hereinafter account, sent via USPS registered mail, article number, blah, 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 by notary public, hereinafter notary, as evidenced by notary certificate of service dated, a record of which is attached hereto and incorporated herein in its entirety as attachment A. Number 2, on May 3rd, 2010, United States Postal Service, hereinafter carrier, delivered the tender to the tender agent. Number 3, on May 28th, 2010, the tender agent accepted the tender for the settlement of the account, as evidenced by the certificate of non-response dated May 28th, 2010, record of which is attached hereto as attachment A. Number 4, on May 28th, 2010, John Henry Doe, hereinafter principal, made presentment of a notice of tender for set-off and a request regarding a statement of account, hereinafter presentment, to John Jones, Chief Financial Officer, ABC Bank, hereinafter respondent, sent via USPS registered mail article number, by the notary, as evidenced by notary certificate of service dated May 28, 2010, a record of which is attached hereto as attachment A. Number 5, on June 4, 2010, the carrier delivered the presentment to the respondent. On June 30, 2010, respondent accepted the terms and provisions of the presentment as evidenced by the certificate of non-response dated June 30th, record of which is attached hereto as attachment A. Number 7, respondent's failure to sufficiently respond or timely honor the presentment by the terms of the presentment constitutes respondent's acceptance and approval of the request regarding a statement of account contained therein. Number 8, as of June 30th, 2010, neither the principal nor the notary have received sufficient response to the presentment. You see why I define all these things? Can you imagine me writing out everything that is the notary, the principal, the presentment, you know? That's why we define these things here and after this, so I don't have to write all of that. I mean, this paragraph would be 3 times as long if I didn't predefine a lot of these words. So we want to say as much as we can and be as concise as possible. So, as of June 30th, 2010, neither the principal nor the notary have received sufficient response to the presentment, thereby placing the respondent at fault, as evidenced by the certificate of non-response dated June 30th, 2010, and the certificate of non-performance dated June 30th, 2010, record of which is attached hereto as attachment A. Number 9, on June 25th, 2010, principal made presentment of a notice of fault and dishonor opportunity to cure to the respondent, dated June 25th, 2010. Hereinafter, defective fault notice. Remember, this process, there were 2 notices of fault sent out. 1 was defective. Sent via USPS registered mail, article number, blah, 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 by the notary. Said defective fault notice contained defects and is rescinded as of June 30th, 2010. On June 30th, 2010, principal made presentment of a notice of fault and dishonor opportunity to cure to the respondent dated June 30th, 2010, hereinafter corrected fault notice, a record of which is attached hereto as attachment A, sent via USPS registered mail, article number, blah, blah, blah. Notice how I didn't include a copy of the defective one, but I did include a copy of the corrected one. Hereinafter corrected fault notice, a record of which is attached hereto as attachment A, sent via USPS registered mail, article number, blah, 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 by the notary, as evidenced by the notary's certificate of service dated June 30th, a record of which is attached hereto as attachment A. Number 11, as of July 12th, 2010, neither the principal nor the notary received sufficient response to the presentment or the corrected fault notice from the respondents, as evidenced by the certificate of non-response / non-performance dated July 12th, 2010, record of which is attached hereto as attachment A. Number 12. Oops, a little too far. Respondent's failure to perform by the terms of the presentment constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. Number 13. Respondent's failure to perform by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the granting and conveying of a specific power. It's basically, I'm outlining the double witness of them granting and conveying the specific power of attorney. So, respondent's failure to perform by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. 14, respondent's failure to sufficiently respond or timely honor the corrected fault notice by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the request regarding a statement of account incorporated with the presentment. Number 15, respondent's acceptance and approval of the request regarding a statement of account constitutes respondent's agreement to the stipulated aggregate amount of unpaid obligation being $0. Number 16, respondent has defaulted. Number 17, as an operation of law, respondent by dishonor of the presentment and corrected fault notice has created a default. Oops. Default. For the respondent's failure to honor the presentment and corrected fault notice places the respondent in default. For the course of dealing set forth herein with the respondent's failure, refusal, or neglect in the presentment of a verified response to the presentment and corrected fault notice constitutes the respondent's failure to perform in good faith and the respondent's acquiescence and tacit agreement with all terms, conditions, and stipulations set forth within the notice of default and dishonor consent to judgment, the presentment, and the corrected fault notice. Therefore, this matter is deemed res judicata and stare decisis. Of this presentment, take due notice and heed, and govern yourself accordingly. This final expression in a record is intended as a complete and exclusive statement of the terms of the agreement between the parties. And then we have here my commercial affidavit and oath. I, John Henry Doe, secure party creditor under my unlimited liability and commercial oath, proceeding in good faith, being of sound mind, having first-hand knowledge, affirm, state, and declare that the facts contained herein are true, correct, and complete, and not misleading, under penalty of international commercial law. So help me God, this 12th day, the 7th month, in the year of our Lord, 2010. Witness my hand and seal. And then, of course, I've got my jurat. What's a jurat? Statement of the notary of what? Of the giving of an oath, right? Enclosures, attachment A, record of presentment and fault notice consisting of A through Q. And you see in there all the elements including the certificate of non-response / non-performance, which was to the notice of fault, right? So, certificate of non-response, non-performance, certificate of non-response to step 2, certificate of non-performance to step 2, the notice of fault and dishonor, opportunity to cure, which was step 3, the request regarding a statement of account, the notice of fault was step 3, notice of tender for set-off, which was step 2, the request regarding a statement of account, which was in step 2, certificate of non-response to step 1, the notice to set off accounts, which was in step 1, the mortgage statement and account money order, which was in step 1, the IRS Form 1040, which was in step 1, the certificate of service from step 1, the USPS Form 3806, return for registered mail, which was from step 1, certificate of service from step 2, the USPS Form 3806, return for registered mail, receipt for registered mail from step 2, 3811 from step 2, notary certificate of service from step 3, and the USPS form from step 3, and the certificate of service for this presentment. That's a complete record. This, in its entirety, including one more document, would be what you would submit. Actually, 2 more documents, because you're going to do one more certificate on this process. Even though, are we asking for a response? Nope. But what was it entitled? Notice of default and dishonor. Consent to judgment. So what am I going to be certifying? Their consent to the judgment. And since I didn't ask for a response, what am I going to use for a response time? A seasonable, reasonable amount of time. Okay? Okay. Okay, this is our... all right. Okay, this is our attachment A, record of presentment and fault notice. So this is for the notice of default and dishonor consent to judgment number, and there's the registered mail number of this particular presentment, and then indexed is everything in our record. This section includes a total of 22 pages, not inclusive of this page. Then here's our certificate of service, and this is probably a 2-pager, I imagine. Indeed it is. 28 pages total. So there is almost our complete record. That was step 4. Okay? Oh, you saw the box? You guys want to read the box?
It's not there for us.
Arg, Garrett. Security agreement. That's it. Okay, in the box, legal notice. The certifying notary is an independent contractor and not a party to this claim. In fact, the certifying notary is a federal witness pursuant to Title 18, Part 1, Chapter 73, Section 1512. Tampering with or is a federal witness. There should be like a comma or something here. Pursuant to Title 18, Part 1, Chapter 73, Section 1512, tampering with a witness, victim, or an informant, certifying notary also performs the functions of a quasi-postal inspector under Homeland Security Act by being compelled to report any violations of U.S. postal regulations as an officer of the Executive Department. Intimidating a notary public under color of law is a violation of Title 18, U.S. Code, Section 242, titled Deprivation of Rights under Color of Law, which primarily governs police misconduct investigations. This statute makes it a crime for any person acting under color of law to willfully deprive any individual residing in the United States or United States of America of those rights protected by the Constitution and U.S. laws. Why is it in a box? It's not there. And why do I not want it there? It's got codes in it, and this is a private contract. Right?
Did you put that on all your documents? I didn't see it, or just this one?
No, I put it on a lot of the certificates of service, but especially as soon as I get to default where they're like, what's this guy saying is going to happen? Okay. Oh, actually, we need to go over here. Okay. Yeah.
Why wouldn't the bank be happy to, why wouldn't the bank be happy to turn everything back to you and give you the zero balance if they've received their payment? Why do you have?
It's a set-off.
It's a set-off?
It's a set-off. They're not happy with it
Why?
because they're greedy.
They want the set-off plus?
No, they want you to submit more debt. They don't want there to be a set-off of the debt.
Set-off can't be fractionalized.
Yeah, set-off can't be fractionalized.
Oh, it just goes to zero and they're done.
Yeah, it's done. That's why people who set off their credit card accounts, the credit cards get shut down. What's in it for the credit card? You're going to set off the debt. Well, now we have no money to pass on to our investors. You see?
They close your account when you do that with a credit card.
Oh, yeah.
They say,
if you do an
"No,
A for
thank
B
you."
on your credit card, count on it getting shut down. Because there's nothing in it for them anymore. You figured out how to set off debt. So why keep... literally, there's no money in it for them. They're not receiving any more debt from you that they pass on to the investors.
Will you not get any offers for bank loans on homes or anything in the future, too?
They can't discriminate. So you can still get credit cards and everything else. You can actually go to this same bank that you just did this process for. You can go get a loan with them again. They can't discriminate, especially because of commercial process, because of set off of debt. Okay. The cool thing about this level of this is the same thing that happens in a bankruptcy. Your debt gets set off, except now there's no public record hindering your credit of a bankruptcy. And why is it? In a bankruptcy, basically what you're doing is you're walking in and confessing, I'm incompetent and can't set off debt. And so who steps in? A trustee steps in and says, well, I will administer your asset account and set off your debt for you, Mr. Incompetent.
I understood, or I was told that in a bankruptcy, collection was stopped, but that creditors were not paid in any way.
And are they paid in this situation? Set off.
Set off is not the same as paid.
No, it's not the same. Because what they consider paid is receiving more debt. They consider a novation of the debt paid. You think the trustee is giving them Federal Reserve notes? Hell no. Trustee is setting off the debt. You have the power to set it off, but you act incompetent. So you go before a trustee. And the trustee, being a trustee, can use your asset to set off your debt. You see? Does that make sense?
I've heard that creditors will come and try and get you to reaffirm a debt.
They can still try to do that after this whole process too.
But if it's set off,
Doesn't matter. They can still come back and affirm it. I could try to affirm a debt tomorrow with you. Watch out. I might send you an invoice. If you don't respond in 30 days, debt's affirmed. That's how it works. It's contract. You just have to be mindful that that's what's always happening. And also, that's a great point to bring up. You're doing this process, you receive a statement of account. What should you do with that statement of account if you're already at step 3? Accept it for value?
Send them a notice of default.
Let's say you've already done the notice of default and you get a statement of account. You could refuse it for cause. You do full acceptance. Are you verifying that you've already established that the balance on the account is 0? But they just sent you a statement of account showing it's not 0. What should you do? Conditionally accept it and send them a copy of your record showing that, oh no, this is 0. Right? Yeah. I conditionally accept that there is still a balance due on this account upon the condition that, or upon proof of claim that, CFO's acceptance of the request regarding a statement of account showing a 0 balance does not constitute a 0 balance in a settlement of this account. If you cannot provide such proof of claim, then you are in agreement that the balance on this account is 0 and that this statement of account is fraudulent, fictitious, defective. Right? But you don't respond to it. What did you just do? You just undid your entire contract that the balance was 0. That is so important and significant for you to get. Remember, we were talking about being competent and keeping your contract. You can make contract all day long. Can you keep it? A contract, if you can keep it. They do indeed.
You can expect maybe a small test or more or something like that to see whether you can keep it, and they're going to do that periodically. Either you know who you are and what you've done, or you don't. You're not going to send it every month for the next 12 months.
And if they do, already have your conditional acceptances made up and ready. And I would make it a one step, because you don't need a due process in responding to this. And it would get expensive. Make it a one-step process in your conditional acceptance and have an affidavit of negative averment in there too. Okay? And then when you get that statement of account, send it off with the conditional acceptance and a note and your affidavit. And in the conditional acceptance, structure it in such a way that you say that if you do not send me a verified statement showing that it is not 0, then you are in agreement that the statement of account accepted by your CFO is the balance on this account. And then when they send you another one, send it again. Send it again. Maybe certify their non-responses to each one. And then you'll have 25 records showing that they're in agreement that the balance is 0. But if you don't respond to one of them, they've got evidence that the balance is not 0. Because remember, they've got a specific address they want you to send the response to that to, don't they? So be careful, because they will be certifying whether or not you respond. Even read the back of your statement of account. It'll say, this comes from a debt collector and pursuant to Title 15 U.S. Code, we are required to tell you that the correspondences associated with this are from a debt collector. Right? What are they saying? That your non-response to this is a validation of this debt. That's what they're saying. No. Nothing has gone into the public record at this point. No. Why would I put my private contract into the public? Okay? So here we are.
I got a question.
Go ahead.
He said he's a secured party creditor in there.
Uh-huh.
In the document. Is that anything special or just a statement?
What do you mean, is it anything special?
Well, they got to do a UCC1, birth certificate bond.
What is a UCC1? Does that make you a secured party creditor?
No.
What makes you a secured party creditor? Security agreement and what else? Your actions, your conduct. That's what makes you a secured party creditor. My assertion that I have the paramount security interest in Brandon A. Adams. Can anyone here challenge that? No? Okay. Then I guess. All righty. Bring your evidence. Yeah, you can challenge it. Bring your evidence. Bring your evidence.
Brandon, just a quick one on the respondent.
Uh-huh.
When you take a mortgage, you usually work with a particular bank, well, like Wells Fargo. So that's on the original documents to start with. And then often that can get changed. It can get changed to another bank.
You mean before you finish this process?
Yeah, could be. I mean, my mortgage actually was with one bank. By the time the papers came, it was another bank.
What papers?
The who you had to pay.
Yeah.
So, right?
But remember, by the time you start and finish a process, the banks aren't going to change. You know what I mean? You're going to complete this process inside of what? 60 days?
Right. But it could change.
If it could, you're going to start a new process.
Start again.
Yeah.
All right. But if you get a service provider that's doing it instead of a bank, because that's what I have now, it may be probably considered a bank, but it's kind of
You're going to be doing it with the bank, and you're going to be giving notice of your process to the service provider.
To the service provider, right, okay.
Okay?
Right.
That's a separate process in of itself because you're going to get their agreement in a separate process. But basically, they have no standing. They have no control. So really, you can wait until you've completed this entire process and then give them notice, hey, your client no longer has an open account or any balance due on this account. Or you can notify them as the bank. Remember, we got a specific power of attorney to execute whatever we need to execute to perfect our security interest, don't we? So I could just send them a letter.
We might request to abate the proceedings pending the completion of the administrative proceeding, a letter attached here
Abate
as
what
exhibit.
Proceedings?
Any collection by the debt collector, a new servicer.
This is the servicer.
A new servicer saying, we want you to send some money. Abate your new service upon completion of this that's in process. You know, I can give you a copy of it. So,
Okay.
process with them.
Well, I would establish, basically, I would just be giving them notice, maybe something like a cease and desist, that their client no longer has any standing. And that unless they can show an affirmed document from the bank that the balance is something other than zero, a verified debt, do like a debt validation kind of type of process, because again, they're not even the creditor. Nor do they assert to be.
And then give them a notice. That's all. Put them on notice,
give them a notice.
That they're trespassing on a contract.
Yeah, exactly.
Brandon, two quick questions.
Okay.
Is it too informal on doing a conditional acceptance if you get one of those notices in the middle of this process to just write it out, a conditional acceptance in your own hand on the presentment and just send it back, or do you think it needs to be more formal?
What is this presentment that you've received?
Well, they're saying, your balance is not zero; it's $100,000.
And you're saying this is from someone at the bank other than the CFO, right?
Yeah, whoever it's from.
Whoever it's from.
Yeah, well, it's somebody.
Are you talking about just a statement?
Just another department at the bank is what he's talking about.
No, I would never write a contract on top of someone else's contract.
Okay.
Because I want it legible. I want them to be able to read it.
Okay, so do the conditional acceptance in a formal way, writing a letter. Because I know people, including myself, who've just written conditionally accepted on proof of claim, blah, 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 and just return it back. That's not sufficient in your mind?
Not for me.
Okay.
I want all my contracts to be legible.
And lastly, quickly, when you go through this process, is it necessary, if you're working towards being a creditor, to contact the credit reporting agencies to have any...
You'd wait till you're complete.
Okay, then you would do that?
You wait till you're complete before you start contacting credit reporting agencies.
Great, thank you.
When I did a RESPA and they I found on my credit report that the bank had discharged my debt. I have a zero balance. Immediately following that, my second line of credit, HELOC, went transferred to Green Tree in the middle of my RESPA thing. That was in 30 days. I mean, it was real fast. Now they're sending me from Home Retention Services, continue to send me recontract things, say 30-day validation, or it's back on. Accepted for value, returned for value with a registered receipt number and no contract written on the bottom. I mean, they come so fast. They're every week.
That sounds like a contradiction.
Right.
Accepted for value, returned for value, no contract.
Yeah.
Yeah, that's a contradiction.
They come
You're either accepting it and returning it for value,
Yeah.
or it's no contract, which I would say just writing no contract, I would probably take it a step further and do some kind of conditional acceptance.
Yeah.
But you do want to respond.
They're coming every week. They keep coming.
Every week?
Yep.
Have a form letter, conditional
Every-
conditional acceptance, and an affidavit
Yeah.
that you just send out with each one. You don't have to even do it through notary because your
Yeah.
evidence and your record is this process, right? Or whatever process you have. So you're just by just having the record from the post office
Yeah.
of what got mailed is sufficient because what are they going to do? Rebut that they didn't get it?
Yeah.
Well, I've got a second witness. The carrier says you did get it.
My point is though, when you push this on them, they're going to get mad. So if they zeroed mine out through the RESPA because it was so bad they didn't want to respond, they're going to be on you with trying to recontract like crazy with
Yeah.
this.
And
And
again,
you got to defend it.
exactly. Can
They're
you
going to
keep
get
it?
mad.
Oh
Can
yeah.
you keep it? Can
And I'm
you
seeing
keep
get
it?
mad.
mine's Bank of America, and it's constant.
Brandon, could you not bundle if you got like 5 in 1 week? Couldn't you bundle them
Oh yeah,
together?
because you could because you've got if they're giving you 30 days on it.
Same number for return mail.
Yeah, you could do that. Put 2 or 3 of them together. Don't wait more than 30 days from the first one. You know what I mean? But
Every week though.
every week, yeah, you may want to bundle them and basically do a conditional acceptance of letter dated this date, letter dated this date, and letter dated this date, which basically say the same thing. Upon proof of claim that the tender was not sufficient to set off, blah, 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 blah. The best request regarding a statement of account does not show that the balance due on this account is $0. You basically just restate your points, have a little accompanying affidavit, because you could do, because there's so few points that you need to make mention of on something like that you could do a 1-page conditional acceptance and a 1-page negative averment affidavit and just bundle that with their letters and send it out to them.
But everybody's going to get these. There's no question about it when they start doing this. So you return the document to them and they keep a copy for yourself. At 45-degree
Yes,
angle, conditional
always.
accepted for value.
No, don't do an accepted for value.
Don't do anything on the document.
Not if you've already set it off.
Another thing is it's not signed. I'd return it for no signature. They don't like that either.
It's just an unvalidated debt.
Exactly.
Yeah, it's just an unverified debt. So all you're going to do is conditionally accept. Okay, I accept on the condition that you send that the tender did not set it off, is not sufficient to set it off, upon that the CFO's acceptance of the statement of account does not constitute a zero balance on the account. That maybe even included some points in there that any further mailings of this type constitutes fraud, constitutes collusion, conspiracy, things like that. Not necessarily charging them for it, but making mention of it so that maybe someone on the receiving end will go, wait, maybe we should stop sending this dude these letters.
I did send a letter that said if I have a guy's name and the chief financial officer and the office of the president's, I happen to get lucky.
Right.
And I sent him a letter that said if he knows of any fraud, then firsthand he may want to go to a judge or a law enforcement agent immediately to protect himself and stop perpetuating fraud, blah, blah, blah. It's actually, I wouldn't want to be the guy receiving it.
Misprision,
Yeah, all
felony.
that crap. Kind of funny, though.
Okay, so are we ready for step 5 yet?
Can you hear
Go
me?
ahead. Yeah.
All right. I did this first step. I did a set-off. They sent me, after I did the set-off, the same statement from the law department. I was in foreclosure, but it was suspended or something. And after I asked them for the payoff statement, and They sent me the statement twice after. So I have to respond to that, correct?
I'm not even clear what happened.
Okay. I asked for the payoff statement.
You asked for a payoff statement.
They gave it to me, and I set it off. I did an A for V on it. And
Through?
And then afterward,
Well, through? Who did you do the set off through? Who did you tender the set off to?
Ogden.
Ogden, okay.
Yeah.
And then they sent you an...
I
Okay,
used the
and
first
then you
step.
got another payoff statement.
Yes. Same document, but
Same date,
no, different date.
send it into Ogden.
Oh, A for V that as well?
Yeah.
So a little different amount on it.
Yeah,
Yeah.
there's a different
Yeah,
amount,
send it
different
into
due
Ogden.
date.
Should he do a complete process on both of them?
No. Send all three of them to Ogden, and then do your process starting with your notice of tender for set off, and make mention that you set this off 3 times. Because really, they're making the claim 3 different times, right?
Okay.
Even if you sent one in, you sent the set off in, then you got the next statement, well then send that statement in. Because really, not until you start sending them the statement of account showing 0 balance are you going to contend their balance, right? It's once you send in that request regarding a statement of account that anything that comes in with a balance other than 0, you want validated. Because we could write them up and send them into Ogden all day long, right?
Right.
But at a certain point, when we've established that it's 0, then we're going to approach it a little differently. So if you have not yet established a 0 balance on the account, then just keep sending it to Ogden.
He did in his first step.
I know. And if he hasn't established a 0 balance, you have to send those other ones in, okay?
Okay. What if I don't have?
I mean, you don't have to. You can do conditional accept, but you're not at step 2 yet.
Yeah.
So since you're not at step 2 yet, just boom, send them off.
Okay.
Okay? And then start with step 2.
What if I don't have the original that they sent?
It doesn't matter. Send a copy.
Well, I don't even think I have it copied.
What
I think
happened
I
to
have.
it?
Well, I think I have one of them. I don't know what happened. I went through my paperwork and I couldn't find it.
All right, well, then it never got there.
All
Send
right,
them
so
whatever
just
whatever
send
you
them
have, send into Ogden.
Okay.
Whatever you've sent into Ogden, make
Should
reference of.
Should I send them more?
I mean, you could put in your process, and I received on such and such a date this, which I lost.
Which I disregarded.
But that's not going to help your process any.
The truth
It's
is
not going
I-
to hurt it, but it's not going to help it.
Okay. Honestly, I think I threw it out.
Okay, yeah, I bet you did. On such and
No,
such a date, I received a presentment of a statement of account,
And I
threw it away.
I disregarded because I already paid it.
Right. Don't just throw stuff away. Okay? Don't just throw stuff away. All righty. What?
Could you image it, or do you keep the original, whatever you have?
I don't keep originals. I always send back the originals. I mean, I keep originals of some of my stuff. I keep original certificates of service, original certificates of non-response. I keep those types of originals. But if I get something from IRS, what I got from IRS is what I send back to them. So if I receive something from Bank of America, what I got from Bank of America is what I send out. I don't keep it, because if I keep it, I'm the trustee on it.
Do you make extra copies of your original certificate?
I make copies of everything.
So I just want you
Yes. Color copies of everything. And actually, I usually do a color and a black and white, because the way my scanner is, if I scan it in color and I print it in black and white, it comes out all crazy. So what I'll do is I'll scan it in color and scan it in black and white, and then depending on whether I want a black and white copy or a color copy, I'll print whichever file I want. And whenever you do a colored copy of an instrument, make sure you do a copy certification on it. Okay? I've got a stamp. It's just a certified copy by a document custodian, and it's like in a box, and I sign it, a number of pages kind of thing. Okay, so here we have, this is our perfecting interest and title. We've got 5 documents here. Document number 1 is a certificate of administrative judgment. Remember, our notice of default was a consent to judgment. And we're going to give them a reasonable amount of time to respond When they fail to respond, we certify their consent to the judgment. Then I have a notice of the administrative judgment. Then I have a substitution of trustee, a notice of rescission, and a deed of full reconveyance, which they gave me specific power of attorney to execute in their behalf. So, Bank of America or Wells Fargo or Countrywide Bank, they're going to execute those 3 documents, and I'm going to do it for them, since they granted me specific power of attorney to do that for them. I'm the creditor. I'm taking responsibility for completing the process and following it through to the end. I'm not depending on them to perform anything. And like I said, once I've gotten through all this and I've gotten certified copies out of the county of those documents, and they're still trying to move forward on a foreclosure or a trustee sale or something ridiculous like that, I'm going to go start a quiet title action. And this record, my complete record, with my certificate of administrative judgment on top and everything in the last step, step 4, the notice of default, which had that entire record of everything, that, with the certificate of administrative judgment on top, that is my record that I'm going to send into chambers, which shows, with like 5 witnesses, that no one has standing but the principal, the paramount security interest holder. And I may even structure my quiet title as a petition with no facts in dispute. Right?
Just like a summary judgment.
Just like a summary judgment. I've already got a judgment. I'm holding a judgment. Right? So I'm going to take that into the court because there are no facts in dispute. No one has any standing besides the paramount security interest holder. So I'm going to make sure that whatever they're trying to do stops immediately. Okay, so we'll look at our certificate of administrative judgment. A lot like a certificate of non-response, presentment, be it known that the person signing below, duly empowered notary public at the request of John Henry Doe and care of notary's address, did duly present on July 12, 2010, the attached notice of default and dishonor consent to judgment, dated July 12, 2010, to Mr. CFO, signed by John Henry Doe, requesting consent to administrative judgment. A reasonable time having elapsed for a seasonable response thereto. Judgment, whereupon the notary public signing below for the reason of consent by non-response does publicly and solemnly certify the consent of all parties it may concern by reason of non-response thereof and stipulations therein. Notice, the undersigned notary public certifies that on July 23, 2010, notice of administrative judgments were sent to the parties noted below by depositing in depository United States Postal Service within the state indicated here in a sealed envelope containing said notices directed to the respective persons or entities at last known corresponding address noted below. Testimony. In testimony of the above, I signed my name and attached my official seal. And no box. Okay. So, document 5.2. And you could actually modify that to take out the notice section, which would include the name and address of sending a notice, and not even send a notice of the administrative judgment. No need. The notice of default was notice of the administrative judgment in reality. You're just certifying that after a reasonable, seasonable time for response, there was none. So they thereby consented to everything in the notice of default. Because if you notice, the notice of default was much more complete in its statement of facts than even the notice of fault. And the notice of default included a record of everything, including certificates of non-response, non-performance at every level, all the USPS records at every level of the presentment or the process. So 5.2 is the notice of administrative judgment. It's much like a notice of default. It just goes through all the points. There's not much difference to it. Okay. Statement of facts, same thing. So you could do this. I most likely wouldn't do this, and I would take that notice section out of the certificate out. It's just a lot of work. It's like, really? Like, do we need to send them another notice? Oh, whoops, that's not what I wanted. Okay, so now we're going to look at.
Do you get a response from any of these?
Typically, no. They're going to consent the whole way. And if they do respond, it's going to be totally insufficient to what we're asking for as far as performance and response. And it probably won't go through a notary. Okay. Substitution of trustee. Now, in reality, substitution of trustee, don't substitute the grantor as the trustee. You've just nullified the trust. You can't have the trustee or the grantor be the trustee and the beneficiary. Okay? So not to say that you're substituting the beneficiary, but again, we want this to look like anything else in the public record, right? We want it to look in form just like anything else. So you wouldn't necessarily do a substitution of trustee. Okay? Because no need. However, if you had a company, let's say, the name of your company was BAA Trustee Company, right? Well, then maybe I would assign BAA Trustee Company as the trustee because that in form looks just like any other substitution of trustee. But if I put John Jones as the trustee, that's going to raise some eyebrows at the county recorder. Who's John Jones? He's never been substituted as a trustee before, right? They're going to think, there's something not right. Now, not to say they aren't obligated to record it, but are you willing to go get the judicial determination it would take to force them to record it?
Simply just form up your trust company. That's all.
You can form up a trust company, or really, is it necessary to execute a substitution of trustee when you've already got a specific power of attorney to execute the other two documents you need, the notice of rescission and the full reconveyance of deed? This is part of the process only because the person I was authoring this for had a corporation that they wanted to make the trustee, and they were going to have that trustee execute what the trustee needed to execute in relation to this, so that any interaction between them and the title company would also go through his trustee company as opposed to the old trustee. Okay? So if you're doing this on a level of executing this on behalf in a benevolent purpose for others, you may want to form some kind of a corporation, LLC or something, and have that be a trustee in your transactions, if you so choose. If you're just doing this for your own personal gain, your own personal situation and circumstances, I don't know if necessarily going out and forming a corporation to be the trustees on these is necessary. But some of you who are going to be doing this in a different capacity, and let's say placing these homes into trusts and things like that, you may want to have some entity to step in as the trustee in order to execute the rest of your business transaction, because there may be some things involved with this property that come after the clearing of the title that you'll need to have an alternative trustee in place. Okay? So this document, although is not necessary for what we need it to look like in the public. Okay? And it's a typical substitution of trustee form. That's why, again, what goes into the public is going to look just like everything else that goes into the public. So if in your state a substitution of trustee looks different than this, make it look like that. Okay? And remember, who's going to be executing this substitution of trustee? The beneficiary. Right? Isn't that who usually executes substitution of trustee? By And then underneath that line, John Henry Doe is attorney in fact for the beneficiary, Alpha Omega Bank National Association. Right? Shit. Yep.
Before the break, I think you said you'd address getting communications from other parts of...
No, I said tomorrow.
Oh, tomorrow, okay.
This is a notice of rescission. So the undersigned beneficiaries, under certain deed of trust dated whatever date, executed by whoever, to whoever, trustee, and that would be executed by, that would be the trustor, to, and that would be the trustee, comma, trustee, recorded at instrument number, as recorded at whatever county recorder, as instrument number whatever, in book whatever, page whatever, of the official records of whatever county, hereby certify that the declaration of default and demand for sale referenced in the notice of default, recorded in as instrument number, in book, page number of official records of, is hereby withdrawn, canceled, rescinded, and declared of no force or effect, and that the election to cause the property secured by the deed of trust to be sold is hereby revoked. It is being understood that the lien of the deed of trust on the property secured thereby shall in no way be affected by this instrument. This merely rescinds the default and goes in before the reconveyance. That's why it is 5.4 and the reconveyance is 5.5. We're rescinding, and again, this is a standard form. This is what the public recorder is used to seeing for a notice of rescission. It's one of their standard forms that they're used to seeing and used to seeing recorded in the county recorder. Whenever someone cures their default and comes out of the default, one of these gets filed. And have you not cured the default on behalf of the debtor? Okay. And who's going to be executing this? Alpha Omega Bank National Association by John Henry Doe, attorney in fact for the beneficiary, Alpha Omega Bank. Right? Did they not grant and convey to you a specific power of attorney to execute this document on their behalf? And the piece de resistance, deed of full reconveyance. Standard form.
Hey, Brandon, before you go into that real quick, when we hear as secured parties, we don't want to ever hire an attorney. Can you give a basic explanation as to what the difference between a attorney in fact is and attorney at law is?
Yeah, an attorney in fact is an individual who's been granted a power of attorney. So and it's actually distinct from an attorney at law. What's the definition of at, Gordon? You know that? No, not at.
As is in the capacity of at is near.
Near. Attorney near law.
Attorney near a contract.
Near law. We're not actually law or in law. We're near it, though. We're getting close. Right? That's an attorney at law.
But if you become an attorney in fact.
In fact.
Right. Nobody can accuse you if you have the proper documentation. You get a power of attorney, proper power of attorney, of impersonating an attorney at law.
No.
Okay.
You specifically put attorney in fact.
Okay. So.
Yeah, don't put attorney at law down here. Okay? That's impersonating an attorney.
Right.
But an attorney, anyone can be an attorney in fact. It takes no special accreditation or designation.
That's
it
what
merely takes someone granting you a power of attorney, which could be verbal. Right. You could say, Brandon, will you go do this for me? Boom, you just granted me a specific power of attorney to do that for you. You can say, Brandon, will you go clean out my bank account and close it? Sure. I go down to the bank. Who are you? I'm Gordon Alexander, here to close the account. They go, okay, here's the proper paperwork. I sign it, Gordon Alexander or Brandon Adams as attorney in fact for Gordon Alexander. Well, let me see your ID. Boom. Well, it doesn't say Gordon Alexander. Oh, I'm the attorney in fact. I've been granted and conveyed a specific power of attorney to execute this document. Right? Now, they may say, well, we're going to need some kind of proof of this.
Memorial or record of it.
Right, memorial or record of this granting of a specific power of attorney. And I may say something like, do you have any evidence that's contrary? Well, then you will execute it. Right? If I know who I am, I'm not going to need to walk in there with any kind of paper power of attorney. I could just say, well, why don't you contact the principal debtor on that account? I told you, I'll give you the ID for my public trust if you feel insecure about authenticating this transaction. Okay, so deed of full reconveyance. Whereas Western Trustee Company, the trustee, under the deed of trust dated March 2nd, 2007, made and executed by Sally Jones as trustor to Alpha Omega Bank National Association as beneficiary and recorded as instrument number 20070000001 on March 8th, 2007 in book blank at page blank of the official records in the Office of the Recorder of Los Angeles County, State of California, having received from beneficiary under said deed of trust a written request to reconvey, reciting that all the sums secured by said deed of trust have been fully paid, and said deed of trust and the note or notes secured thereby having been surrendered to the trustee for cancellation, do hereby reconvey without warranty to the person or persons legally entitled thereto all right, title, and interest heretofore acquired and now held by said trustee under said deed of trust in the real property commonly known as 123 South Dufferin Road, Diamond Bar, California, 91765, situated in the County of Los Angeles, State of California, and more particularly described as follows. County of Los Angeles Assessors, parcel ID number, blah, blah, blah. Date, and signed by Western Trustee Company with John Henry Doe as attorney-in-fact for the trustee. Now, in reality, this document is being executed by the trustee. So, if you had your trustee company set up, you would be executing it as the trustee because the substitution of trustee would have went in before this document. However, you may need a separate process to execute this if you want to leave it under the other trustee. Now, it would be a simple process, and I would make it a one-stepper. And it would go something like this. Notice and demand for execution of, or for the filing and execution and filing of full reconveyance of deed. And the notice and demand would be being made by the bank, right? And I would be signing it as attorney-in-fact for the bank. So I'm telling the trustee, go ahead and execute this. And I'm the bank telling them to do it. And then I could put in that notice and demand that if you don't do this within the next 10 days, that you'll be granting and conveying to me a specific power of attorney to execute it on your behalf. And then I would sign it as the trustee, as attorney-in-fact for the trustee to execute on their behalf. You see? And of course, I would have a certificate of non-response after the 10 days so that I would have a record showing that the trustee had also granted me a specific power of attorney to execute this document on their behalf. Does that make sense? Is everyone clear on that?
That's the trustee for the deed of trust?
Yes.
What if you have a mortgage?
Then this isn't even an issue for you. Right? Okay, notice how, and again, this is a standard form, a reconveyance of deed. That's why there's this little authentication over here on the right-hand side. It says optional, but I would definitely fill it out. Right thumbprint. Yeah, hell yeah, I'm going to put that on there. Let them know. I'm the attorney-in-fact. Here's my right thumbprint to show I'm the attorney-in-fact. Capacity of by signers. What would I check here? Oh, look at there. Attorney-in-fact. Ching. Signers representing. Oh, name of persons or entities. Well, it looks like I'm representing Western Trustee Company. You see that? Nice little form, all made up. perfectly and exactly the way I need it to be. So there we go. Now, again, remember we were saying this is a secured debt process. What would I change in order to make this work for a car loan? Besides some of the wording, right, in step one, because in step one, they're going to be granting and conveying me a specific power of attorney for whatever I need to release the lien on that car, right? So I'm not going to be asking for a reconveyance of deed. I'm going to be saying on such and such a date or on so many days after your acceptance or approval of the statement of account showing zero balance, you will execute or cause to be executed a release of lien, right, on the vehicle. If you do not execute or cause to be executed the release of lien on the vehicle within 72 hours of your acceptance or approval of the statement request regarding a statement of account, then you will be granting and conveying to me a specific power of attorney to execute it on your behalf. And so now I walk into DMV as the bank, and I execute a release of lien on the vehicle. Now, that's getting a little trickier because now we also have to get them to do what? Send you the title, right? If they don't, what do? Go to DMV and get a replacement one. Say, hey, remember there was a release of lien and it's in my name now and I don't have the pink slip. Can you issue me a new one? Right? Or I can go in there in the bank as the bank and say, before I do my release of lien, say, hey, can I get a copy of the title? I'm here for the bank. I'm an attorney in fact for the bank. Now, I would probably go in there with a formal demand signed by the bank as attorney in fact for the bank to give a duplicate copy of the title, right? Once I get the duplicate copy of the title, what am I going to do? I've been granted a specific power of attorney. I'm going to sign it, and I'm going to hand it over to the debtor. And then the debtor's going to walk in there with what? The release of lien in one hand and the pink slip signed to him in the other hand. There you go. Now you got your car, free and clear. No other encumbrances on the vehicle. And you have a contract to back it up.
What about the MSO?
You never get the MSO anyways. If you want to fight for DMV over the MSO, you can, but they're the ones holding it. Bank doesn't have it.
It's incumbent on you if you want that MSO or MCO to get it from the manufacturer when you buy the car.
Yeah.
Otherwise, don't worry about it.
Buy your cars outright. Don't make payments on them. Okay, so, and then, of course, your step 5 here would change ever so slightly to where rather than deed of full reconveyance or notice of rescission, you would have those other documents we were talking about. And you see now how we have a template and we know the pieces so we can really apply this to any situation of secured debt. I could even take this, change it up a little bit, and this could be a process to release someone from prison. This same process. Change the wording here and there, execute a few different documents here in step 5. I've got release from prison.
That's because that person is a vehicle?
The body is collateral, right? So the body is collateral, just like the car is collateral, just like the house is collateral. So anything where collateral is attached to the debt, this process merely needs to be rewritten. Slightly, here and there. Change this piece and this piece. How do you get the penal sum? You don't. Write it as a certified payment bond up to a certain amount. You guys, in the list of instruments you saw, one of those was a certified payment bond. The way the certified payment bond is structured is you make it up to a certain amount and you leave the amount blank. And you have them fill in the amount. So whoever you're making fiduciary for that, which it could be the IRS, right? Because you're the IRS knows the penal sum. If
and you'll tender that instrument as full satisfaction of the claim.
Mm-hmm. Who's the CFO of what? Remember, we're doing all our tendering through who?
Through IRS.
Right.
But I mean, in a penal situation.
Oh, you're saying where would step 2 go?
Right.
You would have to structure step 2 in such a way that who is it that is the beneficiary of the claim? If they're in prison, chances are it's who?
The warden.
No.
At that facility. Or
You could do that, but who's the warden? The warden's a consignor.
Well, it's either going to be the Federal Bureau of Prisons on the federal side or the state.
Even the Federal Bureau of Prisons is a consignee. Who are they holding them for? The state or
Department of Justice?
United States, right? It's either the United States or state of California, right? Or state of Commonwealth of Massachusetts. You could go to the Attorney General of the United States for the United States because it's a fiction. You go to the Attorney General of the Commonwealth of Massachusetts, right?
Just in case that, like, say, you got the everything done, the full recovery, like say the bank stay quiet for 2 years. After that, they send another document to state that you still own whatever, but because they send it for your notary, because not for yourself, if you forget like contact with your notary, you are bad again, no?
If you're saying they send it through your notary.
Yeah.
They send what?
Like say you still own it or whatever. Like say they open another contract in the same.
Yeah, if they could try to send you something, and of course, what are you going to do?
My question is this one: if you lost contact with your notary, you could be in problem.
Oh, if you lose contact with your notary,
yeah.
Dude, they'll never send it through the notary. I've never seen them send any. Actually, the only person I've only had maybe 2 or 3 out of all the administrative processes I've ever done come back through the notary. And usually it's an honorable response. That's the best thing about it. Like when I was telling you guys the story about the traffic ticket I sent into the clerk, and she sent me that letter about we have nothing on record of this case number or the name. Guess who she sent it to? The notary. It was an honorable response, and she sent it honorably through the notary. So typically when you do get a response, it's honorable.
Brandon, thanks so much for sharing this process. It's amazing. Just trying to digest it here. But would you say that people who recommend using, say, the GSA forms for doing mortgage release and or court processes, this is far better? It may take a little more paperwork.
You tell me.
I think it's much more
Where's
solid.
GSA on here?
Yeah.
Where are GSA forms on here?
GSA is in public, right?
Well, let me ask you this. In the realm of possibilities, and in every other case where a mortgage has been discharged, did a GSA form ever appear in the public record? No. Like I said, it's going to simulate, right, any other public process. On the public side, it'll be seamlessly the same thing. It will look exactly like the discharge of any other mortgage.
Do you see any valid usage for the GSA forms?
Not for me. The funny thing is, I look at the GSA forms for what they are. They're prefab contracts. See, a lot of people use my stuff as their prefab contracts, and they replace the names and whatever in it. GSA form, that's all it is. When everyone was going nuts about the 28 and 91, you know what I did? I read them. Then I created my own document that did exactly what the 28 and 91 did. I said, what's happening here? What is the 28 and 91 doing? I said, it's making a pledge of an asset. Oh, and then the 91 is kind of like a trust agreement where it's taking that pledged asset and appointing a fiduciary to do something with that pledged asset. I go, I'm just going to make up a notice of fiduciary appointment. And I'm going to pledge the asset, and I'm going to authorize them to do whatever they need to do with the pledged asset. Basically, I created my own private contract that did everything the 28 and 91 did, except I didn't have to confess to being a U.S. citizen.
Thank you.
Mm-hmm.
Awesome. There's never any set off to zero, then it's just that nobody responds. IRS doesn't respond, the bank doesn't respond. Do you ever get something that says that there was a set off to zero
Yeah, occasionally we do.
Okay, but normally...
Not necessarily on a mortgage, though.
Okay.
They're going to be real hard asses on this kind of stuff because they benefit so much by holding that collateral on their books and by having those securities that their investors are holding and the money that's getting past their security. They're greedy. So, yeah, your credit card companies all day long. Boom, boom, boom. We get the set-offs. We know it happened.
So on a mortgage, all we're doing is giving them reasonable, seasonable, 10 days, 30 days, 3 extra days, all of those days, and then every time that they don't respond, we've got another set of documents, and then eventually something could go into the private in the court if it gets that far.
Yeah.
Okay.
You're establishing agreement.
All right.
It's just a contract.
I'm just trying to understand. It's a very complex thing for me because it's the first time I've seen it.
Oh, okay, yeah. It is definitely, I mean, an administrative process can be as simple as writing a letter. That's how simple it could be. Doesn't have to go through a notary, nothing else. Like, those of you who, you know who Winston Shroud is? Yeah. Okay. Winston is gangsta. Winston don't need no notaries. Winston don't need registered or certified mail. Winston writes it up on a letter in handwriting, folds it up, throws it in an envelope with a 32-cent stamp, sends it off, and just waits. He'll send it to whoever.
He says once it's done, it's done.
It's done, and you better believe he can follow through and make it happen. He walks into court, guess whose court it is? It's Winston's court. Winston don't mess around, but Winston knows who he is. Winston could write this process himself. You know, Winston doesn't need any of the... We established this because it's powerful to have this record. Winston doesn't need no records because he knows who he is. He asserts his rights. And there ain't no undoing Winston's contracts. He knows how to hold them. He knows how to keep them. And he'll make a contract with you right there verbally. And there ain't no undoing it. He knows what he's doing. This should be seen as your gangstification. Okay? You learn this stuff inside and out, and you'll be Winston. You'll be able to walk in anywhere. You'll be throwing your stuff in the envelopes with 32-cent stamps and going, boom, done. Just waiting for them to respond. You know? Because he really knows what he's doing. He knows who he is. So there's no question to him. He doesn't need a notary witness. He doesn't need certified or registered mail.
Brandon, how many times does a collection agency send something certified mail?
Hardly ever.
Hardly ever.
Sometimes they do, though.
Well,
but usually, typically, you know when you'll see it? Collateral. When the IRS is trying to attach a lien or a levy to your collateral, how are they going to send that notice of lien? Certified. Right? When your mortgage company wants to put you in default or sell your home at a trustee or sheriff's sale, how do they send it? Certified.
But not with a notary.
Not with a notary, but that doesn't mean there's not a witness to the process, though. And it doesn't mean that the person who's witnessing it isn't their business to witness it. Because remember, when you have an employee at a corporation, they have no interest in whether the corporation wins or loses on it. So they really are a disinterested third party, even though they're an employee of the corporation. There's really no conflict of interest there. So me, merely as an employee of the IRS, can certify on behalf of the IRS that you didn't respond. Couldn't I? Certified.
At one point in the documents, you were asserting that the mortgage or deed of trust was paid, but that also that the notes were paid and returned. But how would you know that
the notes were paid and returned?
When you were signing as trustee, part of the body of that statement was that...
I don't remember anything about notes.
Yeah, that it also mentioned the note, that the notes were returned.
What are we talking about here? Full reconveyance? That has to be what you're talking about, right?
When you were signing as...
the only thing we signed as trustee was full reconveyance and the notice of rescission. It wouldn't have been the notice of rescission because that has nothing to do.
It's up in the middle of that.
Well, let's take another look here. Whereas Western Trustee Company, the trustee under deed of trust dated blah, 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 and executed by Sally Jones, trustor, and Alpha Omega Bank, National Associated Beneficiary, and recorded as instrument number, blah, 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 on March 8th. In book number, official records, office, recorder, Los Angeles, State, California, having received from beneficiary under said deed of trust a written request to reconvey, reciting that all sums secured by said deed of trust have been fully paid, and said deed of trust and the note or notes secured thereby having been surrendered to the trustee for cancellation, do hereby reconvey without warranty. So yeah, there's a statement there about the surrendering of the note.
But you're not saying that the notes were surrendered to you. You're just saying that, they didn't object to the statement.
No, hold on. Here, where we have reciting that all sums secured by said deed of trust having been fully paid, and said deed of trust and the note or notes secured thereby having been surrendered to the trustee for cancellation, do hereby reconvey without warranty to the person. So, by saying this, that all sums secured by the deed of trust being fully paid and said deed of trust and the note or notes are surrendered to the trustee for cancellation. That may need to be altered ever so slightly. Right? If you're signing as trustee, you can't know whether they've been surrendered. Yeah. But you're also not really attesting to this either. So in reality, if they haven't been surrendered, that is on the bank for not surrendering it, because up until this point, the bank has agreed with everything along the way. Basically, for the bank to say, or the trustee to say, well, wait a minute, the deed of trust and the notes were never surrendered to us, what would they be doing? Well, basically, if we have evidence that they were paid off, we have a record that they're paid off, and they failed to surrender the note, yeah, they're basically confessing that they're breaching their own contract, right? The deed of trust stipulated that upon satisfaction of the debt, they would surrender the note and the deed of trust. So for them to come forward and say, wait a minute, it was never surrendered, they're basically saying, wait a minute, we breached our contract. Aren't they? So I may change this ever so slightly that it would be imperceivable, the difference. And I may say something right about under said deed of trust, a written request to reconvey, reciting that all sums secured by said deed of trust having been fully paid, and said deed of trust and the note or notes secured thereby shall be surrendered to the trustee for cancellation, do hereby reconvey without warranty to the person or persons. Right there. Change that to shall. Or may.
Just don't want to be stating that I know something that I don't.
You're not really stating that you know something, really. That's just it. This particular document, you're just executing for the trustee. You know what I mean? You're not saying, you notice how nowhere on there is there a declaration about this being true, correct, and complete to your knowledge. Because in reality, these documents are never executed by anyone who has firsthand knowledge. You know what I mean? Like in reality, most of these notes are destroyed and digitized. And this is a standard form. So how many people who are signing these things are really signing false statements, considering the note was destroyed? How could it ever be surrendered? You know what I mean? So in reality, we, as taking responsibility for our process to be true and complete, we may alter that wording right there, right? Because we don't want to be signing something that's not true and correct. So I would change probably that wording right there. Bing, to shall. Where's my laser at? Oh, there it is. Having been.
Shall have been surrendered to the trustee.
Yeah. So let's see how I would write that, starting from here. Having received from beneficiary under said deed of trust a written request to reconvey, reciting that all sums secured by said deed of trust have been fully paid, and said deed of trust and the note or notes secured thereby shall be surrendered to the trustee for cancellation. Right? Alrighty.
Any way of throwing this in front of a judge on the private side after everything's done? Before
No. This would definitely, but what you would do is you would take, after you recorded this, get a certified copy out from the county recorder, get a certified copy of anything else. I would get a certified copy of the deed of trust, a certified copy of if there was a default, notice of default, certified copy of the notice of rescission, a certified copy of the deed of full reconveyance. That shows public record of the title being perfected. Then I would take my complete private process as a record. So all of that together, remember, these are actually being submitted in two different forms. One would be under a letter from the notary saying, this is my record of a private process. The other one would be from me saying, this is a record from the county recorder. Because they're two separate records, right? The notary has a record of the entire process. The county recorder has these records. All of those submitted into judges' chambers show all of this on the public side, and consent and agreement and standing and interest, everything I need in order to do, let's say, a quiet title action. Quiet title action would be very simple, just like any other quiet title action, and it would make reference to the records. Now, in the quiet title action, I could attach these records because these are public records. But in the quiet title action, I would not attach my private process.
Isn't there a little hoopla running around right now about going to the registry and recording stuff? I'm not saying it's right or wrong. I've been
the hoopla of going to the registry.
Well, some of the stuff that I was fighting with the bank over was filing fraudulent filings. If they ever came back because you did this, the bank came back at you. I understand you got the whole process, but before you filed anything at the registry of deeds, get a judgment. Is that? I mean, you do this whole process. You've got them dead to rights, and now you put that in front of the judge. The judge stamps it, and then record it. You're saying take your private process and get some kind of an administrative judgment recognition and then
of it.
Give that to the judge on the private side.
Give what to the judge?
Your process with all their acquiescence.
But what are you getting him to stamp?
Well, get him to give you a judgment that you have the thing free and clear, and have them.
Well, then you would need to probably do a quiet title action.
Well, yeah, whatever. I don't know what you'd get out of the judgment.
You don't ask for a benefit from the bank as a plaintiff in that matter. You might petition.
Yeah, I don't know. You're basically saying I'm going to alter this because I have a fear that the bank's going to come after me for fraud. What's fraudulent about this?
Saying that there's anything fraudulent with it.
Okay, so let's say they're gonna make an allegation that it's fraudulent.
Yeah.
What do you have to support that it's not? You have a complete record that shows their agreement to granting and conveying to you specific power of attorney to execute these documents on their behalf.
I'm just saying if there's a way around having to have that fight, because the bank's been fraudulent and doing stuff right along. What makes you think they're going to stop now?
Right,
they're going to be
because
furious.
most people will roll over because they don't know who they are, and they probably have a record supporting their power of attorney, but do they even know that? No, because they took someone's process, put their name all over it, sent it out, and then they got something, oh my God, it's fraud, because they didn't even know what they did. You know? If they knew what they did, they'd probably go, oh, well, They granted and conveyed to me a specific power of attorney to do that. I've got the record of it right here. I'm going to show them that. I'm going to conditionally accept, because remember, what they're going to do is what? First, they're going to make an allegation of it, right? The bank's going to go to you and make an allegation of it. Are they not?
They might go to the feds. I heard
they may go to the feds, but what are the feds going to have to do?
Well, they indict.
They're going to have to show up. They're going to have to interview me about it. Right. Oh, you think it's fraudulent? Well, let me get you a record, sir.
Well, if they hand down an indictment.
Well, is there a defect in that document? Yeah. If there is no defect in the document, what's it matter if that's my signature?
I think Garrett can give us a little bit on
Brandon, if you just change the names and the dates and you don't know what you're doing, aren't you really committing a fraud anyway? Because you have
no knowledge.
You don't know what you're doing.
Yeah, you have no knowledge of what you're doing. And I am not attesting that these are anything other than my private contracts. So if all you're going to do is take my private contracts and slap your names on them, good luck. You know? Especially because you've seen, we've already spotted tons of errors in this document, in these documents. You guys would be fools to go around just putting your name on my stuff.
But some of us are seeing those errors, so it shows that we're not fools.
You're not. Exactly. That's perfect. You guys are being, you have critical thinking skills, which many people out there don't have. I am quite aware that only 2% of the population can make this work, because only 2% of the population has the capacity to critically think. I mean, it's sad, but that's why, as creditors with the capacity of critical thinking, we need to take these on and go out and help our brothers and sisters with what they've got going on. Because you could give them all this paperwork and then it's going to, nobody's home. They can't make this work because they don't have the capacity to think for themselves. They are told what to think. And yeah, you can sit there and tell them what to think, but it's still not going to, the comprehension, the capacity to be fluid with it won't be there. It's unfortunate, and I know this, that only 2% will get this. It's a numbers game. I'm going to teach this to as many people as I can, and the 2% who get it, I believe that the people who show up at the seminars, it's a much higher percentage, because I don't get general population in here. You know what I mean? I mean, if you're coming here, chances are you've kind of already broken out of the matrix. You know, so you're already probably 90% of the people who come to these are critical thinkers, but not 100%, I can tell you for sure. Because I've had people, remember you were telling me yesterday about the lady? How do I get paid? She ain't a critical thinker. Okay? I just want to know how to get paid. Okay. Okay? And there will be small percentages of people who do show up here who don't have that capacity. And they will take the papers, throw their names on them, having no understanding of what they're doing, and get themselves into a lot of trouble. Then point the finger at me. Doesn't matter. They point the finger at me all day long. I know how to handle myself when they show up at my door. She doesn't. And I'm okay with that. With all those incompetents out there who want to point the finger at me, I'm okay with that. I can handle myself, you know. And like I said, I'm playing the numbers game. I'm hoping I'm going to reach that 2%, so that 2% will go out there and save our brothers and sisters. I mean, you're hearing about people killing themselves and their families because they're losing their homes. That just shouldn't be. You know, we have the power to go out there and make a difference. And that's why I do this. We can make a difference. I mean, you realize I'm here today? I'm paying to teach you guys this. I'm not making a dime on this workshop. I'm paying $1,700 to be here for you. It's a numbers game. I want this to be out there. I want people doing what I'm doing, teaching it. I want people executing and saving these families from losing their lives, losing their loved ones, to something that is so ridiculous as incompetency in contract. That's all it is. We all have the capacity to set off debts, and the real shame of it is because of our ignorance, people are dying. People are dying because of our ignorance. That is a shame. So, you're very welcome. And let's get to dinner before we lose time for dinner.